First off, I'd like to acknowledge my respect for and share my deepest gratitude to the Ktunaxa peoples on whose homeland I'm honored to live and work. Today's presentation will be about the Provincial Court Family Rules. These are new rules that came into place last year, and there are lots of cool and interesting changes. And so I'm hoping with today's presentation to go through and highlight some of the major changes and share with you some practical tips in terms of preparing the forms and assisting clients that are seeking to make applications or responding to applications. So in terms of a brief agenda, we have, slightly less than 2 hours. And we're going to go through the new purpose and objective of the rules, talk briefly about the registry requirements. Then we're going to launch into the big topics, applying for orders and making applications generally. Then we're going to talk about 3 new processes that are in place, which are the family management conferences, the family settlement conferences, and trial preparation conferences. Now let's go through briefly the purpose and objective of the rules. Now, having come into force in May of last year, these new rules really aim to encourage parties to resolve case by agreement. It allows parties to work together better. There are more steps that are clearer in order to facilitate, parties coming to decisions by consensus. It aims to really help parties reach timely decisions that are just. It definitely acknowledges the impact of conflict, and especially, high conflict and extended conflicts on children and on their families. And in doing that, we're hoping to minimize that conflict, promote cooperation as much as possible, and create, processes for resolution that are efficient and consistent with the complexities of each case. So the simpler cases we're hoping will exit the system, as quickly as possible. And that is to kind of just minimize conflict and encourage parties to be able to co-parent together. Now, we look at what are family law matters because these applications are about family law matters. Now, family law matters in provincial court, we're likely looking at guardianship, parental responsibilities, where the children reside, parenting time, meaning, what kind of time each parent spends with the children, and contact, where the parties are not guardians. We can also talk about support issues generally, child support, spousal support, as well as some types of protection orders, and also conduct orders. What provincial court, of course, does not deal with and is in the exclusive jurisdiction of the Supreme Court are matters concerning divorce or matters concerning the division of assets, family debts, family property. That's all going to be in British Columbia's Supreme Court. So if you're in provincial court, you're likely working with support issues, protection issues, or things dealing just with children. Now, the new Rule 7 covers which registry you are supposed to file your documents. So previously, this part is a little bit unclear, but the new rules certainly assist in parties deciding, and not so much deciding, but choosing the registry to file in. So first of all, if there is already an existing case dealing with the same 2 people, or it can be more than one party, sometimes we're dealing with step-parents as well, or grandparents. So if we're talking about the same parties, there's already an existing case. The registry is clearly going to be where that current existing case is located. But if you're filing a totally new application and there's no existing case with the same parties, the registry then to be chosen is if the matter involves children and child-related issues, it is the residence where the children live most of the time. So, if most of the children reside in Cranbrook, then the Cranbrook registry has to be the one where you file your initiating application. If there are no child-related issues, so now we're just talking about strict protection orders or strict orders concerning spousal support, we are now talking about the residence of the person who first files the document. So if that one person who's seeking spousal support or protection order resides in Kamloops, then they must file in the Kamloops registry. So there are also designated registries pursuant to these new rules. This means that at those specific designated registries, there's going to be some requirement to complete a needs assessment, a parenting education program, or some type of consensual dispute resolution. It could be with a family justice counselor or another means if you're located at those specific designated registries. Now, I understand some of you may have even taken a course earlier on this month about those designated registries. Surrey and Victoria, for example, are part of the Early Resolution Registry. Then Kelowna, Nanaimo, and Robson Square in Vancouver are part of the Family Justice Registry. There are also other registries around the province from Abbotsford, Campbell River, Chilliwack, Courtenay, Kamloops, New West, North Van, Penticton, Port Coquitlam, Prince George, Richmond, and Vernon. They are part of the Parenting Education Program Registry. And that leaves all other registries that we haven't just spoken about being part of the remaining registries with no additional requirements. This means if you're in, say, Cranbrook or Fernie, you will not need to undertake any other steps, and that you would just file the application, and that would be the first step you take. There's still the availability, of course, to take the online parenting after separation course, which I always recommend parents who are going through separation do. It's fully online, and it's very helpful as a resource for parents to learn about how to co-parent after a separation. That is still available online, but there is no specific requirement to undertake additional steps, although parties will still need to kind of complete that online education program and get a certificate of completion.